It may surprise you that up until recently, some states, namely Louisiana and Oregon, were allowing non-unanimous convictions. That is to say, that you could be convicted of a crime in a jury trial even when not all jurors were convinced of your guilt. That's what happened to the unfortunately named rapper C Murder. C Murder is a rapper who was part of No Limit Records in the 90s. He is the brother of Master P. He has released 9 albums on 6 different labels. His debut solo album was Life or Death in 1998. It peaked at number 3 on the Billboard 200 and number 1 on the top R&B and hip-hop albums and reached platinum status, selling over 1 million copies. Corey Miller, aka C Murder, was arrested in 2002 for the murder of 16-year-old Steve Thomas. In 2003, Miller was convicted after a jury trial. This first conviction was reversed because the prosecution withheld exculpatory evidence. This is also known as a Brady violation. Miller was tried again in 2009, and the jury reached a guilty verdict 10-2. That is 10 jurors for guilty and 2 jurors for not guilty. Miller was sentenced to life in prison. It should also be noted that 2 key witnesses against Miller have recanted their testimony in 2018 and stated they were pressured into testifying against Miller. And at least one of the jurors expressed she was verbally abused and pressured by other jurors to switch her vote from not guilty to guilty. Thankfully, the Supreme Court recently addressed the unanimity of juries in Ramos v. Louisiana in April 2020 and reached the correct conclusion that a unanimous jury is a bedrock principle of the Constitution. And for you to be convicted, all jurors must be convinced beyond a reasonable doubt that you are guilty. So that's great, but now what to do with all the people who were already convicted in trials by juries that weren't unanimous? Well, the majority opinion doesn't opine directly whether the opinion will be made retroactive, but it certainly leaves open the possibility. The majority asserts in response to the dissent, quote, "Taken at its word, the dissent would have us discard a Sixth Amendment right in perpetuity rather than ask 2 states to try a slice of their prior criminal cases. Whether that slice turns out to be large or small, it cannot outweigh the interest we all share in the preservation of our constitutionally promised liberties," end quote. The majority conveys, though, that the ultimate question concerning that application of the Ramos decision to other cases is a question for a future case. Justice Kavanaugh writes a concurring opinion opining that it won't be retroactive, and Justice Alito writes the dissent, and dissents in part because it could be retroactive and could have a large disruptive effect when you consider all the convictions that could be overturned in cases that will need to be retried. I agree with Alito that this ruling could be retroactive, and I agree with the majority opinion that a unanimous jury is a bedrock constitutional principle ingrained in the Sixth Amendment. Not only could this be retroactive, it should be retroactive. The primary concern shouldn't be whatever disruption it causes for the states to reverse convictions and retry people. The primary concern should be to achieve justice. The majority opinion seems to agree with me on that point, that a right to a fair trial outweighs the burden of Louisiana and Oregon having to grant new trials for non-unanimous verdicts. The seminal case on retroactivity is Teague v. Lane. According to Teague, a rule is not retroactive unless 1. the rule is substantive, or 2. the rule is a watershed rule of criminal procedure implicating the fundamental fairness and accuracy of the criminal proceeding. I agree with Justice Kavanaugh that the first exception doesn't apply because required unanimity is not a substantive change, it is a procedural change. Justice Kavanaugh and I part ways on the second exception, though. The second exception of a watershed rule does fit here. a unanimous jury does implicate fundamental fairness and the accuracy of the criminal proceeding. All jurors agreeing on a verdict inherently relates to a jury reaching an accurate verdict. The majority opinion, as well as Justice Sotomayor's concurrence, address the racial implications of non-unanimous juries. States could have 1 or 2 African Americans on a jury and still circumvent them by allowing convictions of 10-2. The adoption of non-unanimous juries were also tied to the rise of the Ku Klux Klan and their efforts to dilute the influence of minorities on juries. The majority of the Supreme Court recognizes this. How then could unanimity in juries not implicate fundamental fairness? It clearly does. It then follows that anyone who has been convicted by a non-unanimous jury should be entitled to a fair trial according to the Supreme Court's own precedent. That would include Corey Miller.